hackers, hustlers, and investors, welcome to FastStart.talk. If you have a startup or early-stage company, FastStart.talk is for you. FastStart.talk is the entrepreneurial voice of Orange County. And now our host, serial entrepreneur, your startup Sherpa, your pivot professor, Michael Sawitz.
Hi, Ashley. Thanks for the intro. We're back in studio, back at octalkradio.net with Paul Roberts on the board.
Yes,
hey, Paul.
Sir. Well, you just hit me with so many great ideas when we do these things, and I can't wait to hear this next one.
Well, I got to tell you, the times they are a-changing. Remember that? Bob Dylan?
I remember it.
We just dated ourselves, Paul. but it's true. The times they are a-changing, and this is definitely true lately, both here in California and nationally, with some very important changes in the independent contractor status. You know, this is really important but confusing stuff, something that will affect about 40% of the entire workforce. And it may possibly affect your startup if you're building an Uber-style business. To help sort through the latest legal challenges in building a business by using independent contractors, I brought one of the most knowledgeable experts in the industry to join our show today. Please welcome Jeff Dinkin. Jeff is the head of the Employment Law Practice Group for Stradling Law, and he's practiced labor and employment law for more than 30 years. Hey, Jeff, welcome to the show.
Thank you. Pleasure to be here.
So, two things are going on that I really want some input on. Let's start with California. And last week, a judge certified a class action suit against Uber. Could you shed some light on that?
Yeah, the Uber case is been going around for some time now. There are about 160,000 Uber drivers that potentially could be subject to this class action. However, the class will actually be smaller based on certain criteria, but there are 160,000 drivers in California with Uber. There's also a similar case against Lyft, and it has to do with the issue of who really controls how those drivers do their job. And in this case, the plaintiffs, which are a small sample of the employees, are claiming that despite Uber's contention to the contrary, that under the law, they're employees. Now, the fact that the Uber drivers, or the majority of Uber drivers, may think they're independent contractors, or may even like being independent contractors, that really doesn't matter. Whether somebody's an independent contractor or not is a question of legal requirements and how they apply to the situation. So here, the judge said that there were sufficient common issues facing all of these Uber drivers so that the determination of independent contractor versus employee status could be determined on a class-wide basis.
So one of the components of this is being able to tell people, where to go, what to do at a certain time or a certain way of performing a job, right?
Yeah, well, the judge, the opinion he wrote was about close to 70 pages. Yeah. So that kind of shows this is not a simple kind of cookie-cutter determination. But the judge said some things, and for entrepreneurs and people with startup businesses who have a lot of pressures on them and are tempted to do this independent contractor thing, it's a risk, and it's something that can be assessed in terms of the likelihood of whether independent contractor status is there or not. But in this case, the court said that the primary question is who controls the method and means of doing the work. And so that's kind of a broad concept, but if you think about it practically, is this person coming in and basically calling the shots for themselves, or are they subject to your ability to tell them how to complete their job? And that's the primary issue. And there's all these sub-factors that help it. An example I give oftentimes, which is pretty simplistic though, is people often have people attend their gardens. And, you tell the gardener that you want a beautiful looking rose patch, and they do what's necessary to tend your roses. Some people are more control freaks, and they decide that they want to tell the gardener how to trim their roses, how often to do it, what bud to trim them at, which kind of shear to use. Those people are taking control over the method and means of achieving the result, which is good-looking roses, whereas the earlier version just says, make my roses look good, how you do it is up to you. And so that's kind of a simple way of expressing that difference.
No, I like that. So let's jump ahead and let's talk about these potential individuals that may be reclassified from independent contractors to employees. If it comes down that court says they're indeed an employee, what does that mean to them?
Well, it means something to them, and it means probably even more to Uber.
Right.
So let's look at the Uber side of things. Well, the first issue is, and why the government is so interested in independent contractor status, is taxes, right? So independent contractors, self-employment taxes, employees, hey, the tax burden on an employee is about, roughly 8.5%, excluding state and federal withholding taxes, but taxes like Social Security, Medicare, unemployment, there's some taxes of about 8.5%. Now, the employee has to contribute about the same amount. The employer is going to be accountable for paying the employee share also if they're found to misclassify employees as independent contractors, and then the employer oftentimes is going to have to go and try to recover that from the employee. So that's a big exposure. There are other exposures too. There's workers' compensation insurance that'll be assessed retroactively in terms of premiums potentially. In the Uber case, a significant exposure is expense reimbursements. The Uber drivers are paying for car insurance. They have gas and mileage and wear and tear. So expenses that the employee incur in doing business for you would be reimbursable if they're employees. On the employee side and the employer side, overtime's a big issue. If you're an employee, you're entitled to overtime, so that's going to be a factor. There are also issues about meal and rest periods and penalties. So the exposure just adds up fairly exponentially, and the statute of limitations on these kind of claims can go back as far as 4 years.
Wow. We're talking about potentially hundreds of millions of dollars.
Oh, phenomenal amounts of money. And that's Uber, but even a startup business, when you think about it, depending upon, how long you've been operating and how many independent contractors you have and what you're paying them, it can be significant as well.
So for Uber, it's all a downside in that they can't go back and say, well, if those people were employees, we'd be paying them a different wage than we do independent contractors who have to cover their own expenses. So they wouldn't be able to go back against the now new employees and say, this is the revenue we did together over the last 4 years. If I have to pay your FICA and so forth, you have to give me back, revenue. I don't think that's going to happen.
Well, they can go. The reason the government generally looks first to the employer to pay the taxes is because they don't want to chase the employee to get paid their tax.
Yeah. Mm-hmm.
The employer, you fail to take the tax out, you go chase the employee, you go get reimbursed.
Yeah, and that's even though the IRS has hired an additional 16,000 auditors in the last couple of years just to do this.
Yeah, not only that, but California and over 20 other states have engaged in a mutual sharing agreement with the IRS. So all of these agencies who are monitoring things like improper classification as independent contractors are now sharing information so that you can get the full shotgun effect of all the agencies coming after you.
Wow, big stuff. So hang on a second, Jeff. We're going to go to a break and come back and get more of this really interesting stuff from you. Hang on.
Are you a startup founder or going it alone? Need help with your prototype, go-to-market strategy, or customer development? Help is here. Fast Start Academy is Orange County's only hands-on learning center for entrepreneurs. Work on your own startup with the help of seasoned professionals. Evening and weekend sessions. Log on to FastStartAcademy.com to see the list of courses and instructors. Or contact us at 949-837-4151. You don't have to go it alone. Fast Start Academy.
All right, let's head back to Michael and his guests.
So, Jeff, with all this going on, how long do you think these kinds of things are going to take to go through the court system so people can start making decisions?
Well, the court really has outlined, in the sharing economy, the Uber type of style, that's going to be playing through the courts. But the decision in Uber, there's been a couple of other cases that have come out involving, surprisingly, drivers and newspaper delivery people tend to be the areas that are most often decided on these independent contractor issues in the courts. But the courts have already indicated what the parameters are for independent contractor assessment, and so I think most companies at this point could probably get an idea about whether they're on the wrong or right side of the decision process on these cases right now, and get a sense of what their exposure is, and then make a business decision about what's right for them.
Okay. That makes sense. So, going on the new posted criteria is the safe way. Just build it as the new law dictates, right?
There are ways, if you have a situation where it's kind of a wobbler about the employee's classification, there are some things you can do to build in some protections to try to make sure that if there is a contest on the issue, that it comes out more likely to come out in your favor. So there are proactive steps you can take. Let me mention another one that I don't want to forget, and that is that a number of companies that have potential independent contractor issues have decided to have their employees, their contractors sign arbitration agreements. And so any dispute related to their engagement as independent contractor, including compensation issues, would have to be decided by individual arbitration. So what that does is for larger companies, smaller companies don't have to worry about it so much, but for larger companies, it takes away the risk of class action lawsuits. Instead, you'll be facing individual arbitrations, with an exception having to do with another statute that's a little more complicated than we need to go into right now.
And that would probably take treble damages off the table as well, right?
Well, you would have the same damages, but it would be on an individual basis.
Right, but now you wouldn't trigger that treble damages clause if you weren't going through court, right? That's not applicable to arbitration?
No, in arbitration, you're entitled to the same damages you could get if you went to court.
Okay.
It's just that you have it heard by a private arbitrator, and you have it heard individually as opposed to in a class basis.
Yeah, because we have lots of new startups that are based on an Uber-style business model. So many people are still out of work. They're not going to get rehired, and this is a way of generating revenue, getting back into business, and actually, creating a life for themselves again. If we lose independent contractor status, it's going to put a lot of pressure back on the unemployed.
Oh, it puts pressure on both the people taking advantage of the sharing economy and the people who are trying to put together a business to operate it. But like I say, there are some steps that can be taken to help to minimize or reduce the risk, and at least get a sense of what it is and make decisions. So rather than just plow into the unknown and hope for the best, it's useful to consider taking some proactive steps to try to structure the relationship to distinguish yourself from what the courts have indicated are causing concern about the classification of independent contractors.
Okay, so let's take a little bit of a diversion off this track. Similar, the same rulings that are determining this that have come out lately from the National Labor Board, and how this can affect franchises.
The National Labor Relations Board, the NLRB, is being very active right now in terms of changing long-standing laws. Preface, the General Counsel of the NLRB issued an opinion which has no legal binding effect, but his attitude is that almost every person is an employee and not an independent contractor. It'll be the rare exception for someone to be an independent contractor. And in the area of joint employment and franchisor relationships, the NLRB is trying to find the deeper pocket and hold the franchisor liable for the conduct of each franchisee. And the basis for that is the same basis we've always looked at, which is the amount of control that the franchisor exercises over the franchisee. And so the NLRB is just applying that in a very aggressive fashion in terms of analyzing the facts.
Okay. Well, being that I've been a franchisor for 30 years, it's something I know a little bit about, and it is about, on the franchise side, it's about brand management. It's managing the reputation of your brand through interaction with your customers. So at every touch, that it's consistent with your brand values. So in order to do that, it's having franchisees committed to following a procedure that gives the same outcome at every touch, no matter, whether it's here in Irvine or, in Russia, China, South America. So by nature, franchising is a set of procedures. So we're in trouble, is what you're saying now. Yeah.
Well, they're trying to make us in trouble. I mean, don't forget, the NLRB is a politically appointed body, and oftentimes they have 3-2 votes, and the composition of the board changes after presidential elections. So this NLRB is reversing precedent that's 50 years old.
And it was a 3-2 vote, yeah.
And it's a 3-2 vote, and so, in 2 or 3 or 4 years, it's possible that the composition will change, and the decision will be contrary. So this area is evolving, but the whole concept is the amount of control that's being exercised over the franchisee, and there are some franchise arrangements where the amount of control and involvement is a bit more than others. So it's just a matter of trying to monitor your activities. And again, it's the NLRB, it's not other places, so they're primarily coming in on union election type of issues and unfair labor practices. So it's a sort of a narrow scope, but still something to pay attention to.
Mm-hmm. Definitely. Do you see, we talked about Uber-style businesses and a shared economy. We talked about franchising. Whatever other, verticals, or how far-reaching do these new decisions go?
Well, the Uber decision is going to be major. I mean, but it's going to be a while. We're dealing with the federal district court right now, and there's going to be a jury trial. So that's going to take a while. I'm not sure when that's going to be done, but next year, I would think. And after that, the chance of an appeal is virtually certain by either side. There's enough money at stake and enough at issue about business structure that there'll be an appeal. So we're looking at 3 years, 4 years, who knows, for a while before we see a final decision. So the law is going to keep evolving, but the court in the Uber case said that what frustrates them is they're trying to apply a 20th century model to a 21st century situation. And so there may be legislative evolution as well in this area.
It's well said. I think you laid it out so that we all can understand that. So with all of these, rulings and changes in the air, people need help. So how do they get help from you, Jeff? How do they find you?
Email is a wonderful thing, and they can email me at jdinkin, that's JDINKIN, at SYCR, that's Stradling, Yoka, Carlson, and Raff, .com.
Okay, one more time, Jeff.
Dinkin, letter J, DINKIN, at SYCR.com.
Excellent. Jeff, thanks for coming on the show. Appreciate it.
Pleasure. Thank you. Bye-bye now.
You've been listening to Fast Start Talk, brought to you by Fast Start Studio. and Orange County's only community radio station, OCTalkRadio.net.